I'll just announce we have a security announcement by one of our investigators.
One of them will jump up.
Good morning, everyone. Good morning. Let's be seated. Before we get started, we'll have our usual security announcement by whoever's being pointed to back in the back there. Ms. Blanian? You point, but there's no one there, sir. Okay. Good morning.
So we'll do the same as yesterday. If there's an issue and we need to clear the room, we'll exit through the door where the issue is not. We'll get back under this one. We'll deal with the problem and hopefully get it resolved quickly without a big deal. So that's it.
Thank you very much. All right, well, good morning, everyone. Thank you for joining us for this Dental Board of California meeting. I'm Alan Felsenfeld, and I serve as the president of the board. Today is Friday, August 18th, 2023. This board meeting is being held in person. Depending on the number of people who would like to testify on a particular agenda item, a total time limit of 2 minutes will be imposed. When 30 seconds is left within your 2 minutes, you will be notified. In that 2 minutes, we're going to ask you to stop speaking. We ask all speakers to please stay on topic and not repeat testimony already provided. If you agree with the testimony provided, state your name and that you are in support of the comments previously provided. If a time limit is necessary, keep your comments within that time limit. I would like to call the meeting to order and ask the board secretary to please call the roll.
Good morning, this is Lily Larine, Board Secretary. I will now call the roll. Chan?
Jan, present.
Chan, present. Felsenfeld?
Felsenfeld, present.
Felsenfeld, present. Forge?
Forge present.
Forge, present. Larine, present. McKenzie?
McKenzie here.
McKenzie, present. Medina?
Medina present.
Medina, present. Molina?
Molina here.
Molina, present. Olage?
Olagi here.
Olage, present. Pacheco?
Pacheco present.
Pacheco, present. Thakur? Absent. You
Present.
present. We have a quorum.
Thank you. Once again, like yesterday, I'm going to ask all speakers to please give me a break, keep your microphone close to you, and speak in an outside voice so we can hear you clearly. My congestion has not gotten too much better. We're going to move on to item number 21, the board president's report on closed session items. We held a closed session meeting last night, and the board voted on 2 petitions for reconsideration. Is there any public comment? Seeing none, we're going to move on now to item number 22, the Dental Assisting Council meeting report. Ms. Tracy Reed Espinoza, the chair of the Dental Assisting Council, if you'll present this agenda.
Good morning, board. Yesterday, the DAC met, and we have a couple of items to review with the board. Agenda item number 3, what's the minutes? There was a correction that was advised and taken under consideration. Agenda item number 4, executive officer report. Dr. Tracy Montaz gave an update and no action was needed. Agenda item number 5, dental assistant exam statistics. Mrs. Ricky Parks provided an update. No action was needed. Agenda item number 6, dental assistant licensing statistics. Mrs. Ricky Parks provided an update. No action was taken. Agenda item number 7, dental assistants expanded function program and course approval on-site. Mrs. Ricky Parks provided update and no action was needed. Agenda item number 8 was pulled from the agenda. Agenda item 9, discussions of possible recommendations and regulation penalty and fraudulent advertising information in regards to dental assistant education programs. A motion was put forward to go to the board for possible consideration of citations running from $500 to $5,000. Agenda item number 10, Mr. David Bergman updated us on legislation, and there was going to be a public hearing on August 25th. Agenda item number 11, possible recommendations for pending legislation AB 481. This is not a bill that the DAC has done. This is just recommendations that we put forward in regards to wording on this bill. 1747.5B a request for replacement of application to graduation. After further review, this has been retracted. We're going to keep with the application. 1750.1A, line 11, dental assistants may cure dental materials used for procedures with light cure devices. We just requested that you remove orthodontic and it just be for all DAs. 1752.4B, page 121, line 21. Perform oral health assessments, extraoral evaluation of soft tissue, perform myofunctional evaluation and oral cancer screening as authorized by the supervising dentist. Intraoral assessments limited to identifying oral lesions, classifications of occlusion, performing myofunctional evaluation and oral cancer screening as authorized by supervised dentist, and techniques to acquire a final impression address the specific area receiving treatment. 1752.4C, line 4, this is regarding implants. Placement and removal of healing caps, transfer abutments, and to add other attachments. 1753.1, line 13, additional education will be required for an RDA EF2 graduating after June 1st of 2024 in order to perform the new duties in regards to AB 481 legislation. No grandfather clause. 1753.3, line 3, in regards to endo, we're requesting not just fit trial endodontic filling points, but as it is right now in the laws, we requested to add back size, fit endodontic master points, and accessory points for cementation and arbitration of a master point. That concludes my report. Thank you.
Thank you very much. Are there any board comments on the report of the Dental Assisting Committee? Seeing none, is there any public comment? Thank you very much.
Thank you.
Appreciate your work. We are now going to move on to item number 23A, status update on the pending regulations. Mr. Bruggeman, would you come forward? And Ms. Shield will be with you in just a moment, okay? Thank you.
Good morning, President Felsenfeld and board members. I'm David Bruggeman. I'm the Legislative and Regulatory Specialist for the board. I simply want to briefly update the board on the movement of packages since the last board meeting. There are 3 active packages that have moved forward since that board meeting. Our package to implement the legislation, the AB 107, establishing temporary licensure for qualified spouses or partners of military members. This is an update from what is in the memo. The package is currently in the 45-day notice period. We have received 1 adverse comment, so at a future board meeting, the board will need to consider and respond to that adverse comment and any other adverse comments that we receive between now and the end of the 45-day notice period, which is on September 12th. With respect to the package concerning updating the board's disciplinary guidelines, that package has moved from the review from the Department of Consumer Affairs to review with the Business Consumer Affairs and Housing Agency, which is the cabinet-level organization that oversees the department. Once that review has been has been completed, we would then proceed with filing that package with the Office of Administrative Law and starting the 45-day 45-day comment period. There's the third package concerns updates for the processes on lost, destroyed, and mutilated licenses, and the process to either activate an inactive license or to seek inactive status. that package remains with board staff for review before proceeding with, before moving the package to the Department of Consumer Affairs for review. And that concludes my report on the packages that have moved forward since the last board meeting.
Thank you. Are there board member questions or comments for Mr. Bergerman? Things keep moving. Any public comment on this report? Seeing none, we're going to move on now to item 23B. And that will be consideration of previously approved proposed regulations and a possible recommendation to form an advisory working group to review the dental assisting comprehensive rulemaking regulations. We have with us Ms. Christy Sledge, who has been with us verbally, at least for a couple of meetings. She is an attorney in the Regulations Unit, Legal Affairs Division of the Department of Consumer Affairs. Good morning, Ms. Sledge.
Good morning, and I hope you all have had an opportunity to review the additional amended agenda item for this item. It's dated August 15th, 2023, a memo to the board members about concerns with the currently proposed text. So just a little bit of background. When regulations are reviewed for approval, there are various control agencies that review the regulations. The first agency is through the director of this department, the Department of Consumer Affairs. She'll review any regulations you approve to move forward. After she reviews it and approves it, it would move to the Business Consumer Services and Housing Agency, and their secretary and counsel would review it. Then after that, the Department of Finance would review the economic and fiscal impact statements that are associated with the regulations, and the Office of Administrative Law, at least 3 attorneys there, would be reviewing the regulations. The regulations are reviewed to see whether they meet 6 standards. Those 6 standards include necessity, authority, clarity, consistency, reference, and non-duplication. I worked on the existing regulations you have for the educational programs back in 2010 and 2011, so I know a bit about your rules in regard to this issue. I was also private post-secondaries, the Bureau for Private Post-Secondaries counsel for about a decade, so I have a lot of experience in education law. And that experience back in 2010 was very instructive, but I can tell you that since those 12 years have passed, that the rigor with which they review regulations has increased quite significantly, and the things perhaps that we adopted back in 2011 may not be acceptable upon re-review by the control agencies that I mentioned. So I've learned a lot since that time, and I think I can help with this package, put it where it needs to be to get that approval that you need to update your regulations. I would agree they do need to be updated. But the current proposal that was originally approved in December of 2020 by this board and is included in the materials at Attachment A has significant issues, as I outlined in the memo. About every standard is implicated, meaning I think you would have a difficult time getting this package through the control agencies and meeting those 6 standards for the reasons I've outlined in this memo. I mean, no disrespect to those that were involved in the process, but I think I look at things through a different lens after working with the department for over 23 years, and I can tell you that there are issues that need to be addressed, in my opinion. So my recommendation is included on page 5 of the memo, to request that you rescind your prior motion, because the only way I can work on updating the regulations is if you rescind your approval of the prior text. My recommendation would be to send it back to the Dental Assisting Council, ask them to appoint a 1 or 2 person working group so that we can quickly move through our revisions and bring back a proposal to the Dental Assisting Council for review and approval, hopefully. And I think there's ways of approaching it that I'd like to work with the working group on, that perhaps we could have this move a little more quickly, maybe take pieces at a time as opposed to a giant package 300 pages long. And so I want to make sure that you all understand I'm committed to working on that, but I need your permission to do that. So that's why we brought this item to you today.
Oh, yes.
So if any questions that the board members have on the memo or anything that I've reported?
Okay, at this point, I'm getting a little feedback. I've got my hearing aids on now. I've had to your benefit, I've had a little ear infection or something.
sorry.
No, you're sorry. You should see it from my end. Anyway, I can hear now. That's great. Thank you. Want to repeat all that again? No, just a thought. Let's see if we can put this into my simple mind. Number one, we did something a long time ago. We started to send it upstairs. It never got any further on these regulations. And you're suggesting that maybe they're not exactly where we should be in this day and age. Bring them back. Let's take a group and revise them and then send them forward again. Is that where it is in the simple?
Correct.
Thank you very much. All right, so is there any board discussion on the issue? Seeing none, we're going to make a motion then. Who would like to do that?
It would be on page 5, I suggest. of
No,
the
it is
memo.
page 5, and you can read it, but someone has
Oh.
to make the motion. Who would like to do that?
Pacheco.
All right, Dr. Lorin? Oh, I'm sorry, who's, all right, don't fight, kids. Dr. Lorin, go ahead.
Do you want me to read it, or Dr. Loren?
She'll do that for you. I think we can actually do all three of these as one.
Yes.
They do work well together, so we don't have to separate them. Go ahead, Dr. Lorin.
The motion is to rescind the board's December 4th, 2020 motion to initiate a rulemaking for this proposal, refer this proposal back to the board's dental assisting council for the appointment of a 1 or 2-person working group to further review and revise the proposal in consultation with the Regulations Council and board staff. And the last one is bring back a new proposal to a future meeting for board consideration.
Thank you very much. Is there a second?
Belagi, second.
Thank you, Alagi. We have board member discussion on the motion. There does not appear to be any. Is there any public comment on the motion? Everyone's looking back. There's no one coming forward. I think we're ready to vote. Dr. Lorin, would you like to call the
Oh,
vote?
wait.
I'm sorry. Was there someone coming forward? I'm sorry. Sherry, please, Ms. Becker. Didn't see you, didn't see you.
Sherry Becker, representing the Alliance. Thank you. Sorry, I didn't stand up fast enough. We are in support of this motion.
Thank you. And Dr. Gallardi.
Hi. Good morning. Lori Gallardi representing FADE, and we too are in support of the motion, but we'll ask this time if you could put a timeline perhaps on as we go forward with certain times that, if you're going to review a certain amount of information, will stakeholders have the opportunity for input and to get that input back to you, or do we just wait until the reg hearing, or maybe you could just explain a little bit more
Sure.
for us how this will work?
No problem. So part of the problem here is that the proposal was reviewed by council that was new to this board and the department and regulations in general. So there wasn't a lot of guidance, I think, provided to the prior staff. And so my recommendation would be to refer this to the council, who would appoint a 1 or 2-person committee to work directly with staff and myself to make sure there's that engagement and get that subject matter expertise. I don't presume to be an expert in this particular area. The educators would be those experts. We would consult with hopefully someone that council appoints that have that experience. My experience last time I worked with Dr. Witcher on the regulations. So then it would be brought back to the council at a public meeting. So at that time, we would explain the recommendations and the changes from the prior proposal. We would go through that advisory group, so to speak, the council, who's your advisor on dental assisting matters. And at that time, the public would have the opportunity, and I welcome it because I'd prefer to work through the issues before we formally file the rulemaking. The fewer adverse comments, the more quickly the proposal in the formal process can move through. If we wait till the formal rulemaking to take the adverse comments and engage, then the rulemaking slows down quite significantly. It takes a lot longer. So if we can do it up front, that would be the goal. And so that's why I'm suggesting this approach, because it has worked for us in the past, and it's worked for other boards that have had similar complex, outdated regulations that need to be addressed.
That makes sense. I think Dr. Montez would like to speak to this.
I just wanted to confirm what you said about doing the work
behind the scenes in the work group and then bringing it to the Dental Assisting Council meeting for public input and again, helping clarify. So if we can get in the weeds in the working group
Yes.
and get things done, then it's a much cleaner approach to the council. And then again, if we do that in an iterative process as we work through sections, then we'll have one nice package for the board and then moving forward. So thank you, Christy.
You're welcome.
Okay, is there any additional public comment?
I did have one more
Yes,
additional
ma'am,
thing.
of course.
So I do what I can to move things through, but of course, I can't do it all by myself. So if we're going to set timeframes, it'll have to be, in coordination with staff and the working group's schedule. That's kind of out of my control. So I can't set the schedule, so to speak. It would need to be something that would be managed through the staff. So,
That's understandable, and if this does pass, then you will coordinate with Dr. Montez and make
Correct.
that happen for you.
thank you.
Any further comment from the public on this? Wait, we got more.
Sorry, Lori Gallardi representing Faith. Just to clarify, the next. Oh, is that-
It's got a light going.
Oh.
But that's okay.
Thank you. Lori Gallardi representing Faith. Just to clarify then, would this go back to DAC then, not until the October-November meeting to appoint the subcommittee? Or is this something the dental board could appoint a subcommittee when you have two of your members on DAC now?
I think we need to wait until the November meeting. The October meeting is to look at sunset, so it will be only a board meeting. However, there's plenty of work we can do between now and November. So I would prefer to do that. We've got a lot on our plate getting ready for sunset, so.
Thank you. Any additional public comment? Seeing none, it looks like we're ready to vote. Dr. Levin, would you please take the vote?
Chan,
Chan, aye.
Chan, I, Felsenfeld,
Felsenfeld, aye.
Felsenfeld, I, Forge,
Forge, aye.
Forge, I, Larin, I, McKenzie,
McKenzie, yes.
McKenzie, I, Medina,
Medina, aye.
Medina, I, Molina,
Molina, aye.
Molina, I, Olage,
Olagi,
Olage, I, Pacheco,
Pacheco, aye.
Pacheco, I, you,
You, aye.
you, I. Motion passes.
Thank you very much. And Ms. Shields, thank you very much.
Thank you.
Nice to see you in person. We are now going to move on to item 24A and B, if I'm not mistaken. And it's going to be a report on the CDCA and Western Regional Border and ADEX exam. And we don't have a representative, but Dr. Montez says she'd try to give us the information that we have.
Good morning. Good morning. So Ms. Regali and I are going to run through these slides for you. Unfortunately, they had a conflict, an unscheduled conflict come up and could not be here with us today. And we just received word, I think it was Wednesday. So they have provided us with slides. And if the board members want to go around, it's a very short PowerPoint with some data. And we can also get you copies at a later date. But what I wanted to do is just go through the slides to show you some information. They claimed it's very self-explanatory. But if you do have questions about it, I'm happy if I can't, well, I won't be able likely to answer them. Paige may be able to. Or we will get those to our representatives. And they can provide responses either at our next meeting or we can get them to you. So the next slide presents the number of dental hygiene and dental graduate initial ADEX clinical attempts by mid-year. And so it shows the sections of the exam, and there's been an increase, obviously, since we have moved over to ADEX. And Paige, feel free to jump in at any point if you have any additional information you'd like to add. Moving on to the next slide, they're going to give us they're giving us data on the dental class of 2023 year-to-date through June 30th. And again, here you can see the number of candidates that took the endodontics exam We have the initial attempt passing percentage at 84%, which is good. We always like to see a high percentage for our first-time test takers. Next slide. And then they show the most common errors, which I think is helpful for our students, so they know what they're doing wrong or incorrect. We have the prosthodontics are on the next slide. And again, another high initial or first-time pass rate. And then errors, common errors that are made. We go into the perio. Again, another high initial pass rate, almost perfect there. And you see we have the simulations versus the patient and the common errors. And then the next slide, anterior restorative. This is when we get into the use of their new Competent, which was one of the things that we were quite impressed with. I know when the Office of Professional Examination Services did their review of this exam, this was something that we'd like to see to get away from the patients because of the potential lack of standardization. So the Competent does provide some standardization for the candidates. And again, the common errors there. And then last, we have the posterior restorative. Again, passing rates and the errors that are made. They also use the Competent here. So, what I can extract from this, from my background, is that the exam seems to be doing a pretty good job in terms of what we would expect for individuals at this level, the dentistry level, a higher pass rate because of all the training and education. Our first-time attempts are high, that's good. I like to see that we've got more people using the Competent. I can't attest to why they have the choice. That would probably be something that they would have to ask or answer. But I also like, too, that they're providing information about common errors that contribute to the failure so that students can learn from that. So this is their very brief presentation. And like I said, we'll make sure that everybody gets copies of that, as well as we'll post it on the website so the public will have it as well. And if you have any initial questions, I'd be happy to attempt to answer them, or Paige, or we will get them to our representatives at CDCA, REB, and CETA.
This is an informational item. Are there any board member questions or discussion points? Seeing none, is there any public comment? Okay, very good. Let us move on then to the next item, which is item 24B. And this is going to be presentation, discussion, and possible action on the portfolio examination report by the Office of Professional Examination Services. I'm going to ask Dr. Montez to take this one as well.
Yes, thank you very much. Unfortunately, OPS, or Office of Professional Examination Services, is tied up at a couple other board meetings. There's a lot going on with regard to testing this week in board meetings. But I am more than happy to take this item. So basically, I'm going to read a little bit from our background here. As you know, our boards and bureaus within the Department of Consumer Affairs are required to ensure that all of our examination programs used in California, the licensure process, comply with psychometric and legal standards. And so we had OPS do an evaluation of the portfolio pathway, and this is something that OPS has been involved with for quite some time. The board put together this additional pathway, and so in order to meet these standards, it's important to have a review of examinations on a regular basis. So prior to my tenure here, the board entered into a contract with OPS to do an evaluation of the portfolio exam, and found a number of concerns with the examination. And so based upon their review, and part of that review has to do with just the exam is not really being used as it was initially intended to. There's a lot of psychometric steps that need to be taken in order to do this type of exam, and therefore candidates, over time have really moved toward using the ADEX exams that are nationally accepted, whereas the portfolio is not. So over time, this pathway, its value has changed, and so given the psychometric concerns as well as the practical value of the pathway, OPS has recommended that we eliminate this, that the board eliminate this pathway. And so they basically have asked the board to consider the findings of OPS and potentially move forward to remove this pathway. So with that, I will open it up to board questions, comments, and I know Dr. Felsenfeld would like to say something.
I would like to say a lot, but let's let Dr. Chan go first.
I've tracked the driver for this pathway as well as the construction of this, and there was a lot of heart that was put into this. But in the 10 years, more than 10 years now that this has been on the table, the consumption's not there. And putting this amount of resources, it's time for extinction.
Thank you, Dr. Chan. Anyone else want to talk to this, speak to this in any way on the board? I do. And Dr. Chan, you're absolutely correct. In full disclosure, the way the portfolio came about was looking for a new way to license dentists without having to take all these exams that we had to take way back in the day. And there was a group of three organizations. The dental board was represented pretty much by Steve Casagrande. The schools were represented by various deans and professors, and it kept varying, and I represented the California Dental Association. So I spent about 3 years of my life approximately trying to put this together. And you're right, it was a very difficult thing. We spent a lot of time, we looked around, and I have an emotional attachment to this because I think it's the right way to let it go. Finish dental school, get your license, end of discussion. That's not what the rules are today, and I understand that as president of the board, we have to follow those rules, but that's the way it should be. That's the way it is in medical school. Why is it different in dentistry? That being said, I also recognize the functional reality of the fact that no one is taking it. The reason they're not taking it, it became very difficult because of the regulatory requirements, nothing personal. It became very difficult for the schools to actually administer this exam. So the schools lost the enthusiasm to kind of set it up for these students to take it. In all of the time this has been there, at my school at UCLA, where I was teaching forever, one student took it. Some of the other schools took it. So I have to suggest, as much as it pains me, that we need to vote yes on this and eliminate the exam. It's just not doing what it's supposed to. There are other things that can come in the future, and I'm going to continue to push for those as well. Any other board comments? Ms. Welsh.
If the board moves forward with this legislative proposal today, I have some recommended changes to the text.
And that will be occurring after we say yes, if that's what it comes down to. Do you want to talk about them now?
I'd prefer to talk about them now. That way, if someone makes a motion, they can include these revisions in the
Please
motion.
do. Please do. I think that's the
Tara, before you go into the changes, I would just, again, emphasize, because of course this is my background, testing, so whenever I have a chance, to get up on my soapbox, I'm going to do so. But this is a really good example of why we evaluate examinations on a regular basis, because the portfolio was a great idea. It worked for a time, but then it became outdated. And we're using ADEX. And so it's so important that we always keep in mind that an exam is not just an exam. It's a process that we need to keep evaluating through our occupational analysis, through our exam development, and so forth. So although, it's a hard thing to let go, it's a good example of evolving tests and not having barriers to licensure. So I'll step down off my soapbox now. Thank you.
Thank you, Dr. Montez. Ms. Wells.
I think it might be helpful to display the meeting materials for this as I walk through some of these corrections. So specifically, I'm hoping we can display page 148 of the meeting materials. Yeah, I can, alternatively, I think most of these are minor and technical. So I can just walk us through it. If members of the public have a packet, something to look at, and I can just explain what the changes are and why.
If they're truly technical, that should
Yeah.
not be a big problem. Go ahead, Ms. Welch,
Okay.
get started.
Page 148 of the meeting materials, in the title of the legislative proposal, strike elective facial cosmetic surgery permit and credentialing committee, and instead insert portfolio examination.
You're suggesting we call it by the right thing, is what you're saying?
Yes.
All right, that's a good point.
This is
Move on.
technical. Page 149 of the meeting materials. About halfway on that page, in the sentence that begins "in either case," on the third line, strike at the end of the sentence, "or as provided in paragraph 1 of subdivision C." That paragraph 1 of subdivision C refers to the portfolio examination provisions that we're striking today, so that is no longer necessary. That sentence would end at "examination was administered." On page 150 of the meeting materials, in section 1632.5, subdivision A, middle of the page, retain the strike-through text of paragraph 2 of, retain that, and then number 2, change that to 1. This conforms to the changes being made to section 1632 subdivision C, paragraph 1, which will now be the REB provisions instead of the portfolio examination. At the end of that sentence, 6 lines down, it strikes, the text currently strikes paragraph 2 of, let's go ahead and retain paragraph 2 of, but change 2 to be 1. For the same reason, we're just conforming it so that the new text will just refer to the REB exam, not the portfolio exam. I'm also recommending that you strike at the end of this line, it begins, "The review of the Western Regional Examining Board examination shall be conducted." I think the board needs to strike that whole sentence because it's outdated. And the following sentence, beginning with, "However, an applicant who successfully completes the REB on or after January 1, 2005, I think that needs to come out as well. Both of those sentences are outdated, and I would also note that those are not included in the ADEX provisions that we'll talk about in a second. So that 1632.5A will just be one sentence ending with "Section 1632 shall not be implemented."
Okay.
Moving on. Page 151 of the meeting materials, Section 1632.55, subdivision A. The text currently strikes subparagraph B of paragraph 2 of. I'm recommending we retain the words paragraph 2 of, because paragraph 2 of subdivision C of section 1632 properly references the ADEX exam. So we do not need to strike paragraph 2 of. So I'd like to retain those words. Then, toward the end of that subdivision, on the line that begins "described in subdivision D," I would like to strike subparagraph B of. That's coming out as well. That's it. Just technical revisions.
Thank you very much. I would look at these as all technical corrections and not substantive. In theory, we could just leave it that way, but I think we'll have the board take a vote on that to make sure we're all in agreement that these are reasonable things to put into and then we'll vote on the entire process. So is there board comment on these technical changes that, Dr. Liren?
I'm just a little confused because we're mentioning Western Regional Exam, and that doesn't exist anymore. I'm confused about that it's no longer existence. REB has joined CDCA.
It's
so
all one.
It's all one, it's not called REB anymore.
Do you want to respond? I do not. Okay. We're called, you have an area in the notes here where it is called REB, and we need to change that? Is that what you're suggesting, or?
If this is for the future, REB no longer exists right now.
We understand that. And
If
show
this-
me where
if this
tell
is
me where you're
speaking about,
talking.
Everything here. It says the Western Regional Examination process shall be regularly reviewed by the Department of, I mean, it mentions that a lot.
Ms. Regali is going to come up here and address this. Thank you.
Thank you.
Good morning. So just to kind of address your concerns, we understand that REB is no longer in its own self, its own entity, and its own examination that we offer. However, it's still a pathway to licensure currently. So we still do allow the REB pathway to licensure. So the different statutory provisions regarding the acceptance of the examination in relation to that pathway to licensure would still stand for now. So basically how it is and how it works with the board is that you can have taken the REB exam within the last 5 years and those scores will count. So since the REB exam was administered through December 31st of 2022, you would still essentially be able to apply for up to 5 years from December 31st of 2022 to meet that application date and those requirements. No problem.
So that should take care of that. Okay.
Thanks, Paige.
Are there any other board questions or comments on these technical changes? Seeing none, this is going to be voted upon, so I guess we're going to need a motion to accept the technical corrections that our attorney has left for us. I'll be happy to move that. Is there a second? Dr. Chan, thank you very much. Any further board discussion on the motion? Is there any public discussion on the motion? Seeing none, we're ready to vote. We're voting on the technical correction before we vote on the actual full scope of the motion. Dr. Levine, would you be kind enough to take the roll?
The roll. Okay, Chan?
Chan, aye.
Chan, aye. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, aye. Forge?
Forge, aye.
Forge, aye. Ladine, aye. McKenzie?
McKenzie, yes.
McKenzie, aye. Medina?
Medina, aye.
Medina, aye. Molina?
Molina, aye.
Molina, aye. Olage? Olage, aye. Pacheco?
Pacheco, aye.
Pacheco, aye. You?
UI.
You, aye. Motion passes.
Thank you, Dr. Lorien. Now, we have the entire motion, which I think was made by me, if I'm not mistaken, and seconded by Dr. Chan. That's correct. So we have that motion before us, and let me see where we are on the schedule. It is the motion on page, help me out here.
146.
146, all right, 146. There you go, option one, I believe it is. So it's option one, that's the motion that's before us. Any further board discussion? Seeing none. Is there any public discussion on the motion as it's written? Dr. Witcher, are you coming up? Yes, no? No. In a minute. That's later. Okay, thank you, Dr. Witcher. Let us take the vote then. Dr. Lorien? Microphone?
Motion, option one. Read it.
Please do.
Move to recommend inclusion in the board's sunset review report, the legislative proposal to amend Business and Professions Code, Section 1632, 1632.5, and 1632.55, and repeal Section 1632.1.
As amended.
As
As
amended.
amended. We made some changes to it. As amended. Thank you.
Chan,
Chan, aye.
Felsenfeld,
Felsenfeld, aye.
Felsenfeld, aye. Forge,
Forge, aye.
Forge, aye. Ladine, aye. McKenzie,
McKenzie, yes.
McKenzie, aye. Medina,
Medina, aye.
Medina, aye. Molina,
Molina, aye.
Molina, aye. Olage,
Olage, aye.
Olage, aye. Pacheco,
Pacheco, aye.
Pacheco, aye. You,
UI.
you, aye. Motion passes.
Thank you very much. I believe we now move on to item number 25 on our agenda, and that would be an update regarding the board's sunset review process. Dr. Montez.
Good morning again. Tracy Montez. As you are aware, every board and bureau in the Department of Consumer Affairs is subject to oversight by the relevant policy committees of the California State Legislature. Every few years, each board and bureau goes through what is called sunset review process. It's called sunset review because the authority of each board expires or sunsets on a specified date. However, the sunset review is typically completed several months prior prior to that date. So as you are aware, we have started our sunset process because our authority is set to sunset on January 1st, 2025. Board staff is currently working on our report, and as I had mentioned in my executive officer's report, we will be meeting October 12th, presenting the report to the draft report to the board to review, and then also the public for comment as well. And then this will go through the final reviews, hopefully the different agencies will look at it, and then it will be submitted to the legislature early January, and then we anticipate a hearing in March. And so we look forward to feedback on the report, and we'll do our very best to get it posted with adequate time for our stakeholders to review and comment in October. The meeting will be here in Sacramento, and we anticipate about a 4-hour meeting depending upon how things go. So we hope you can all join us. Any questions about Sunset, our Sunset update?
Any board member questions first? Any comments? It's still in the offing. We don't have any real information. Public comments. Looks like Dr. Witcher. Please identify yourself, though.
Dr. Bruce Witcher, CDA. Hate to do this, but I'd like to raise a point of order. I believe the previous motion was to approve the changes, and that you were going to take a subsequent vote to approve the motion as a whole.
We actually did, sir.
Oh, you combined those, okay.
No, I did not. We had two separate motions.
Oh, okay, sorry.
You're welcome. Have a seat. It's easy to make that mistake. All right. That was a point of order from before. Okay. So this is an informational piece. There's nothing that we need to say. Any public comment? I don't know if I just asked for public comment. I thought that's what that was going to be. Any other public comment on the sunset review process? Seeing none, we're ready to move on. Let us go to item 26A. This is a discussion and possible action on the revisions to the previously approved recommendation on legislative proposal to amend B&P Code Section 1601.1 and 1740, to repeal BPC Section 1742 regarding board composition and dental assisting counsel. Mr. Brueggemann, please enlighten us.
Hello, everyone. This is David Brueggemann again, Legislative and Regulatory Specialist for the Board. I'm speaking with respect to the item on the meeting materials starting on page 154. At the May board meeting, there was discussion and the board approved technically two separate proposals related to these sections of the Business and Professions Code. It was the substance of the proposals was to eliminate the dental assisting council and then to also adjust the membership of the dental board to reduce the number of public members by 1 from 5 to 4, to increase the number of dental assistant members from 1 to 2, and to specify particular qualifications for those dental assisting members. As you may recall from the meeting, there was a lot of discussion, a lot of feedback, both during the meeting and subsequent to the meeting, and it was effectively communicated to board staff and board members that there was a lot of resistance to this idea, and there were specific concerns that warrant, in the estimation of the staff, bringing back the proposal for consideration by the board. Specifically, with respect to the changes to the composition of the board, the reduction in public members from 5 to 4 is likely to meet with resistance within the legislature and also within other various components that are rightfully concerned about ensuring that the interests of the public are adequately represented as the board conducts its business. We're responsible for regulating a profession. We do not represent the profession per se, and ensuring that there's a significant public input through the membership of the board is an interest that the legislature, we anticipate, would be very concerned about maintaining. In fact, if you go through the legislative history, when the Dental Assisting Council was created, the number of public members was increased on the board from 4 to 5. And so, based on the considerations of that, we would encourage the rescinding of the proposal to reduce the number of public members on the board. We would also encourage the board to consider rescinding the proposal to eliminate the dental assistant council, because based on the feedback from both the meeting and subsequent to the meeting, we believe there's been significant demonstration of an interest in you working through the dental assistant council to better engage with the board and to better represent the interests of stakeholders of the public and the profession in its business. So that's the essence of the staff recommendation, to rescind those proposals, and that concludes my report, and I'd like to open it up for discussion at this point.
Thank you, Mr. Bruggeman. Is there any board member discussion on this issue? Dr. Chan?
I'm going to address the section about altering the numbers of public members. Just as background, I was president-elect of the California Dental Association when the issue of restraint of trade came before the Supreme Court. It was FTC versus CDA. It was a multi-year process in discovery, and it cost millions of dollars to go through that. So I'm really sensitive to restraint of trade questions in there. The differences as we move forward with North Carolina Board of Dental Examiners is that the North Carolina Board at that time was populated by recommendations from the Dental Association. It's different than in California. California is not populated, the dentists are not populated by the Dental Association, so there are differences. But then if it does go through and the board becomes a target for that, it's going to cost. And we have to defend ourselves. It's not worth it. It is really not worth it. I understand the need for the public members. I absolutely do. And we balance out the optics that this is a regulatory board of dentists and dentistry against the public interest. So I do understand the reasoning behind rescinding that. Thank you.
Thank you, Dr. Chan. Is there any other comment from the board members? Are you going to, you want to speak, Dr. Moran? Go ahead.
I'm actually very happy to see that we are reconsidering the function of the Dental Assisting Council in their input, because like I had mentioned, made a comment in the last meeting, I think that it's really important that we hear what they have to say in their input, because, you know, we are dentists, work with dental assistants, and they're part of our team. So I'm very happy to see that this is back in the process.
Thank you. We don't have a motion yet, so would you like to make a motion, Dr. Chan, on this? Sure. All right, go ahead.
I'm going to move that we support the proposed recommendation to move to withdraw the approved legislative proposal for inclusion in the board sunset review report to amend section 1601.1 and 1740 and repeal section 1742 of the Business and Professions Code.
Is there a second?
Second, Pacheco.
I hear someone say I'll second. I don't know who, Dr. Forge, thank you. All right, so we have that before us. Is there any further board discussion on this? Is there public comment on this? Good morning.
Good morning,
Melody?
left it on.
Thank you,
Good
Brenda.
morning, Melody Randolph, representing the Alliance. As you can imagine, we're delighted to hear this, and we recognize all of the hard work of the DAC, and would just like to encourage the board in moving forward, and if you're going to keep the DAC, to really listen to their comments and concerns and their suggestions, as they do work very, very hard, diligently, to represent dental assisting. And so we're delighted if this passes, and hope that we can move forward positively. Thank you.
Thank you, Ms. Randolph. Is there any other public comment? Oh, careful. Is there any other public comment?
Sherry Becker, representing Sherry Becker.
You're welcome to do that.
I agree with everything that Melody Randolph just said. Thank you.
All right, thank you, Ms. Becker. Any other public comment? It looks like we're ready to vote. Just to be clear, would you read the motion one more time? And I want to make one comment just before you take the vote.
Okay. Where is that motion? Which one was it?
It's probably on page 156.
Move to withdraw the approved legislative proposal for inclusion in the board's sunset review report to amend section 1601.1 and 1740 and repeal section 1742 of the Business and Professions Code.
Thank you. Just to be clear, a yes vote means you want to withdraw it. A no vote means you want to leave it the way it was. Take the vote, please. Is there a question on that?
So if we vote yes, is status quo.
Speak to the microphone so I can hear you better. If you vote yes,
Just to clarify,
Yes.
when you're voting yes, then that means that we're keeping the status quo.
no, that is not correct. A yes, the motion is to withdraw it. So if you vote yes, you want to withdraw it, and not to withdraw the elimination of the council.
Okay.
I think you want to vote yes is what you're telling me.
Yes.
Okay, thank you very much. I was trying to make it clear that obviously didn't work. All right, Dr. Liren. Everyone's clear on what we're voting on. Is that correct? Okay, very good.
Chan,
Chan, aye.
aye. Felsenfeld.
Felsenfeld, aye.
Felsenfeld, aye. Forge.
Forge, aye.
Forge, aye. Larin, aye. McKenzie.
McKenzie, yes.
McKenzie, aye. Medina.
Medina, aye.
Aye. Molina.
Molina, aye.
Molina, aye. Olage.
Olagi, aye.
Olage, aye. Pacheco.
Pacheco, aye.
Pacheco, aye. You.
You, aye.
You, aye. Motion passes.
All right, thank you very much. Dr. Montez would like to make a comment.
I would just like to really thank the board for being open to these conversations and the actions that were taken in May and taken today. And thank the stakeholders for speaking up, because in addition to being heard, we're also, board staff are going to ask for assistance. And we now have a RDA reg package, so we have a big project as well as some other things that we're working on. So we appreciate the partnership. And again, we're going to ask for assistance and work because board staff only have so much bandwidth. And so again, I think this is a good way to energize things moving forward. And I know you've done a lot of great work in the past, so let's keep moving forward. Thank you.
Thank you. Mr. Bergman, I think you're done for now. We're going to go on to item 26B, a discussion and possible action on the legislative proposal to amend BPC Section 1638.1 regarding elective facial cosmetic surgery permit and credentialing committee. I'm going to ask Ms. Regali to present this for us. No, she is. Good.
Thank you, Dr. Felsenfeld, and good morning, members of the board. My name is Paige Regali, and I will be presenting agenda item 26B. This begins on page 158 of your meeting materials. Senate Bill 438 enacted Business and Professions Code 1638.1 to require a licensed dentist in California who is not a physician and surgeon to apply for and receive an elective facial cosmetic surgery permit. On June 27, 2006, the Assembly Committee on Business and Professions hearing analysis explained that the need for the bill is to respond to the board's interpretation of the Dental Practice Act, and that licensed dentists could only perform oral and maxillofacial surgery when the surgery was related to and part of treatment for a dental condition. The analysis further noted that proponents of SB 438 believe that dentists should not be restricted from performing procedures for which they were trained during their 4-plus-year hospital-based surgical residency program as part of their oral and maxillofacial surgical education. In addition, SB 438 also enacted the EFCS Credentialing Committee, which is comprised of 5 members who are appointed by the board and meet as needed to review applications. Board staff have identified various issues with the application requirements and process, which have also been raised as concerns from the committee. In an attempt to streamline the application process, create more efficiency, and reduce barriers to licensure, board staff propose amendments to Business and Professions Code Section 1638.1 to clarify the permit application requirements as well as renewal requirements. The proposed amendments are as follows. Restructuring statutory provisions to conform with new permit structure used for general anesthesia and sedation permits. Require a current dental license in good standing as defined to perform EFCS. Move existing subdivision A2, which is a permit renewal, to new subdivision K with technical revisions. Clarify the categories of an EFCS permit that may be issued to either 1 or 2 or 1 and 2. Removing the limited privileges category. And clarify requirements for operative reports, including requiring a specific level of participation be listed on the report, and other information such as when the report took place and other various things, which the committee also recommended. Removing the current requirement for the committee to review permit holders' competency every 6 years and replacing it with a new requirement of 24 hours of CE in elective facial cosmetic surgery for each biennial renewal cycle. Non-renewal of old permits with limitations and reissuance of permits to newly proposed pursuant to the newly proposed subdivision M. The proposed amendments would establish the procedure for the old permit that was issued with limitations to be reissued under the new categories of either unlimited privileges in 1 and 2 or unlimited privileges in 1 or 2. In addition to the proposed revisions to the application and renewal requirements, staff also propose repealing the committee who would be contracted with these revisions as subject matter experts to still review application on an as-needed basis in an effort to remove barriers to licensure and establish a more efficient application review process. Today, the action that's requested is board staff is asking the board to discuss and consider the above-described legislative proposal. If the board approves of this legislative proposal, the board is asked to include in the board's next sunset review report a recommendation to amend Business and Professions Code 1638.1 to clarify the EFCS permit application process and requirements.
Excuse me, is there any board member discussion on this? Seeing none. Is there any public comment on this? We haven't got a motion yet. Excuse me one second, Dr. Witcher. Let's get a motion on this first, okay? And then we'll call for public comment. Does anyone want to remove this for us? I will. Okay. Do we have the actual motion written out in front of us so I can read it into the record, Mr. Gully? It's on page.
163 of the meeting materials.
163, thank you. I'll just read it into the record. And that's here. And the motion is to, all right, the recommend, all right, so what we're really doing here is we're trying to make a motion to recommend to amend Business and Professions Code 1638.1 to clarify the application process as we have written in all of this preliminary information as I see it.
Correct.
All right. Ms. Welch.
And included in the sunset review report.
And include it, thank you. And do that and include this in the sunset, absolutely correct. So that is the motion. The motion is to, I'll make it clear again, is to amend B&P Code Section 1638.1 to clarify the AFCS permit application process as indicated in our study and to include it in the board's sunset review legislation. Is there a second? Dr. Chan seconded, thank you. Is there any board discussion on this? Ms. Pacheco?
So to clarify, this is then the same as the 20 cases for the children under 7?
What, I think what you're, Ms. Regatta, go
Yeah.
ahead.
So the intent here is essentially, we have a very small population of elective facial cosmetic surgery permit holders. When I last checked, we have only issued ever 38 permits since this statute was enacted, and only 26 of those are currently in an active status. We believe, board staff believe, in conjunction with meeting with the committee on quarterly basis and receiving feedback from them, that there were a lot of issues with the statute as it was currently written. I know there was proposed regulations, but we're hoping to avoid having to put regulations forward and move forward with that package by making putting more detail into the statute and the requirements of the permit, just to include the operative reports, 10 operative reports within the sections, but the operative reports never had a requirement of what was included on the reports, so now we want them to notice what their level of participation was in the surgical procedures, as well as when the actual operative or operations took place. So we are asking for more clarity within the application, which will help board staff to review the applications based on the statutory requirements, and then it would alleviate barriers to licensure, because our intent is to then use the committee as subject matter experts and no longer have a committee. This would be more efficient. We wouldn't have to set up quarterly meetings. We wouldn't have to make the applicants wait for licensure, which, depending on when our quarterly meetings are, they still have to wait another month to come before the board. So there's a lot of stuff that we're just trying to kind of clean up and make a lot more efficient on both our end and for the applicants as well.
Thank you. You good? Any other board comments on this? The motion is before us. Any other board comments? Ms. Welch, once again.
Just a clarifying point, Ms. Pacheco mentioned 20 reports that have to be submitted regarding pediatric procedures, and I think that's the SB 501, 20 reports. This is different in that current law only requires 10 reports to be submitted for these types of procedures. This is not general anesthesia and sedation. It's completely separate from SB 501, and this was implemented back in 2006. What you are seeing is that if the individual is applying for both Category 1 and Category 2 procedures, then they would have to submit 20 reports. But if they're only applying for one or the other category, it's just 10 per category. So that's where the 20 is coming from. I just want to be clear, it should not be confused. Thank you.
I don't think that was her intention there, but we're good. I think she was trying to look to an analogous thing that the board staff does relative to general anesthesia. That's fine. Any other board member comments on this? Seeing none. Public comment. Okay.
Thank you, Chairman. Felsenfeld, Gary Cooper, representing Cal Amos, the California Association of Oral and Maxillofacial Surgeons. Cal Amos were the sponsors of SB 438 in 2006, and they worked very, very hard to convince the legislature and the governor to allow the oral and maxillofacial surgeons to participate in this technique. And during that process, it was very difficult. There was a lot of struggle with the medical profession, and I wasn't involved in it at the time, but I was very aware of how it shook out. Right now, we're very supportive of a lot of the issues that have been brought forth today, streamlining the process. The one we have more concerns with is eliminating and repealing the committee. We believe that with public safety involved, and we are very much involved in patient safety, as we were with SB 501, which is why we sponsored SB 501 in the first place, which you keep hearing about every 4 months. We're very proud of that piece of legislation, and we're very proud that it is helpful in consumer safety and patient safety. So what I would ask is that if you could have a substitute motion to move forward with all of this streamlining as we've done in SB 501, but continue on with the committee. You can certainly meet by Zoom, as the advent of Zoom these days is much more than it ever was before, and you're shaking your head no. Through the chair. Oh, okay.
Finish your comment, Dr. Cooper.
Okay, absolutely. Thank you for the promotion of Dr. Cooper, by the way.
That's fine.
We are very supportive of the suggestions, with exception of the repeal of the committee. We would ask that it remain, or like to see a substitute motion accepting all the provisions with the exception of the repeal of the committee. We certainly, as Cal Amos, would provide a certain, a directory of many, many professionals who would be willing to participate in this committee. But at this point in time, we think it's not helpful for consumer safety to eliminate the committee. Thank you.
Thank you. Any other public comment? Dr. Witcher.
Dr. Bruce Witcher, speaking as an individual and former liaison to the EFCS committee when I was on the board, and Ms. Regali can attest to this, I always thought that this committee was one of our more effective standing committees. They did a really good job with application review. Now, that said, I can understand why you might see a potential efficiency in eliminating it, because they only meet when there's applications that are completed to review, and with the number of permits, that's a small number. So I get that. I would submit, though, that it may be premature to consider this at this time for the following reasons. First of all, we have pending legislation that may make remote meeting participation much more possible. That's SB 544 and I think 2449. And SB 544 is due out of appropriations next week, so we'll know more about the future of virtual meetings at that time. I understand you're facing some deadline issues with Sunset Review coming up and wanting to get your proposal in, but I would just put that out there. The other issue is that this is a somewhat controversial topic, as Gary mentioned, when the legislation was originally proposed. And there is a provision in existing law that when the committee is constituted, the committee composition needs to be run by a number of communities of interest, including CDA, CMA, California Society of Plastic Surgeons, and Cal Amos. I know that if you sunset the entire section,
30 seconds, Dr.
that will probably not be necessary. But just consider there are communities of interest you may want to consult with before moving forward with reconstituting the committee. The other issue is that I would like to make sure that these permittees who have had limited permits will be treated fairly when they reapply. Practice evolves. You may not do the procedures that made you eligible for the permit in the first place 10 or 20 years later, because your practice patterns may be of change.
Okay.
So I would ask that you
Time, Dr. Witcher.
Yeah, okay.
We heard that. Thank you very much, sir.
Okay.
All right. Any other public comment on this proposal, on this motion? Are we good here on the staff and attorney side? Okay. We're going to take the vote then. Dr. Loreen, would you please repeat the motion, if you will, and we'll call the roll. Sorry.
To include in the board's next sunset review report, a recommendation to amend Business and Profession Code Section 1638.1 to clarify the EFCS permit application process and requirements. Is that good? Okay.
We good? Sure.
Chan?
Chan, aye.
Felsenfeld?
Felsenfeld, aye.
Borge?
Borge, aye.
Borge, aye. Larin, aye. McKenzie?
Mackenzie, yes.
McKenzie, aye. Medina?
Medina, aye.
Medina, aye. Molina?
Molina, aye.
Molina, aye. Olage?
Olagi, aye.
Olage, aye. Pacheco?
Pacheco, aye.
Pacheco, aye. You, aye.
You, aye.
You, aye, sorry. Motion passes.
Thank you, Dr. Loreen. We'll now move on to item number 26C, discussion and a possible action on legislative proposal to amend BPC Section 1718.3 regarding issuance of a new license in the event of a failure to renew within 5 years after expiration. Ms. Regali, I think this is yours again.
Yes, thank you, Dr. Felsenfeld. I will now present agenda item 26C, beginning on page 170 of your meeting materials. Licensees who do not renew within 5 years of their expiration date are then put into a canceled status. The licensee may then apply for and obtain a new license to replace the canceled license if they can satisfy all requirements listed in Business and Professions Code 1718.3. As it is currently written, this section requires licensees who have allowed their license to cancel to pay past due renewal and delinquency fees that have accrued since the last time the license was renewed, and pay all applicable fees for a new license application for whichever pathway they would be applying through. The current section also states that they must pass an examination or provide satisfaction that they can practice within the profession and apply using one of the 5 available pathways to licensure. Assembly Bill 1519 amended BPC Section 1718.3 during the board's last sunset review and added a new provision which requires the license holder to apply for licensure as a new applicant through an available pathway and meet all of those requirements for licensure under that pathway. The intent of that amendment was to allow those with canceled licenses to utilize the current process or apply for licensure through one of the available pathways such as REB, ADEX, licensure by credential, licensure by residency, or the portfolio pathway. Board staff believed that this would allow those who did qualify through an available pathway to gain access to licensure without the barriers of waiting on quarterly board meetings for review and significantly decrease the amount of canceled license applications received. By adding this new provision, board staff believe this would also ensure licensees seeking to practice in California establish that they were qualified to safely practice and ensuring competency and current standards of the profession. Board staff have concerns regarding the interpretation of the current statute it is written, and the ability to allow license holders to return to practice after extended periods of time without sufficiently establishing that they are competent and safe to practice with the current standards. Board staff also have concerns regarding the time spent reviewing and communicating with license holders about the requirements in BPC Section 1718.3 that lack clarity and uniformity. After consideration of the current process, the concerns raised, and review of the statutory provisions, board staff propose amending BPC Section 1718.3 to strike the confusing provisions in paragraph 3 so that all license holders seeking to obtain a new license after cancellation would apply for licensure through a current available pathway. This proposed change is in alignment with the board's mission of consumer protection and better reflects the effort in the board's last sunset review that established stricter requirements for licensure pathways to ensure competency and current professional standards. The proposed statutory amendments will benefit licensees, consumers, and board staff by better identifying clear expectations of license holders with canceled license wanting to gain licensure in California again. Board staff also acknowledge that there are certain licensing populations who may not qualify for licensure under these current requirements and proposed amendments, and therefore we have drafted 2 proposals for your review. Options A and B both clarify the fees due when a license holder is applying for new licensure under this section, and both options also strike subdivision A3, which requires a license holder to provide satisfactory proof that they are safe to practice. The difference between the 2 proposals is that option B will allow an exemption based on license holders who were previously eligible for an examination pursuant to subdivision E of section 1628, which allows graduates of non-CODA approved schools to take a licensing examination that was administered by the board. This option will allow them to be eligible to take a licensure examination under section 1632 and qualify through an available pathway such as the ADEX examination. The action requested today is that the board is asked to discuss and consider the above described legislative proposals. If the board approves of the legislative proposal, the board is asked to include in the board's next sunset review a recommendation to amend Business and Professions Code, Section 1718.3, to clarify canceled license application process and requirements. Thank you.
Thank you. Is there any board discussion on this with either of the 2 options? As I understand it, oh, go ahead, Dr. Leary.
No, I just wanted to mention, we have to start eliminating the REB, because the REB is no longer in existence, the exam, and I just meant, it was mentioned again.
Where does it say REB?
So it's not an examination that's currently offered, but it's still a pathway to licensure. So that's why it's not eliminated. So even though they cannot take a REB examination now, because after the merger, they no longer offer the REB exam. However, because of the statutory provisions that allow applicants to use their scores as long as they've taken and passed within the past 5 years, they're still able to apply for licensure. And we even see, we see scores in REB applications still today because the last exam was administered in December of 22. So there's still quite a few applications we receive through the REB pathway.
I have just a quick question by way of summary for me. What you're saying in paragraph 1 is make up your fees or your delinquent dues or whatever you need, pay us. Number 2, you no longer have to take another exam to get your license renewed because you did that once before. Is that correct so far?
So the way that it's currently written, with the amendments from the last Sunset Review report in AB 1519, they added a paragraph, but it wasn't structured properly. So the statute now requires everything in paragraphs 1 through 4 for someone to restore, reinstate, essentially regain licensure in California after a license has canceled, which just means that it lapsed for 5 years due to non-renewal and the license automatically went into a canceled status. So the way that it's now written is that it allows or it requires someone to provide satisfactory proof, which is the subparagraph 3, which we're proposing to strike, as well as apply through a new pathway to licensure. So they kind of contradict themselves, and the intent behind it was to allow people with canceled licenses to not have to go through a review process and essentially not have a canceled license pathway. The intent was to allow them to apply through a pathway that they qualify for. Essentially, we would see licensure by credential because, most of the time they move out of state, they practice somewhere else. They've allowed their California license to lapse and cancel, and therefore they want to come back to California and they've worked clinically for 5 years, someone else, they can qualify. The option 2 portion is because if we remove that provision and there's no longer a canceled license pathway, we recognize that there is a population that qualified previously when they were graduates of foreign dental schools or non-CODA approved dental schools, and they then qualified to take a board administered examination, which was a restorative technique exam. So if we remove the option of the paragraph 3 and we only allow them to qualify through new license or through one of the available pathways, since they don't have a CODA approved education, and if they have not moved somewhere and practiced clinically the 5 years, we wanted to still allow an option for that population to regain licensure. So now they would qualify to take an examination that's given under 1632, which essentially would only be an 8X examination and all other exams required for licensure.
More user-friendly is what I'm getting.
Yes.
Thank you. Any other board discussion on this? And we don't have a motion as yet, but would someone like to make a motion? Dr. Forge.
The motion is to include in the board's next Sunset Review report to amend Business and Profession Code Section 1718.3 to clarify the canceled license application process and requirements.
As which option?
With option A or B?
I'm sorry, say that again?
With option,
You got to pick an option.
It's 1 or 2. Which option do you want? The one that includes the non?
So A would be the option, both options are identical. Essentially, we're restructuring the fees and we're removing that subparagraph for clarity. However, option B would allow for that additional licensing population who may not qualify through one of the available pathways to have that exemption to still take an examination required under 1632 to qualify for licensure. So it would just be, the first one is a little more limiting in a sense, and the second one would take into consideration all populations who could have a canceled license.
and option B.
Thank you, Dr. Forge. Is there a second?
I'll second.
Thank you, Ms. McKenzie. Is there board discussion on that? Seeing none, is there any public comment on that?
Dr. Bruce Witcher, representing CDA. I guess we had a little bit of a concern about the delinquency fees and what purpose those would really serve. If somebody comes back and wants to reinstate their licensure and they're still eligible after having it canceled for 5 years, they can establish eligibility through one of the pathways. It almost seems like the delinquency fees are a little punitive. I mean, sure, charge them the fees going forward for application and issuance of a new license and all that, but the retroactive fees can really add up and be quite a burden to somebody trying to come back to state. Thank you.
Thank you. Any other public comment? It looks like we're ready to vote. Dr. Loreen, if you'll be kind enough to read the resolution once again, and we'll take a vote.
To
to include in the board's next sunset review report a recommendation to amend Business and Professions Code Section 1718.3 to clarify the canceled license application process and requirements. And option B, legislative proposal to amend Business and Professions Code Section 1718.3 regarding canceled license.
Thank you. We all know what we're voting on. Take the roll, please.
Chan.
Chan, aye.
Chan, aye. Felsenfeld.
Felsenfeld, aye.
Forge.
Forge, aye.
Forge, aye. Larin, aye. McKenzie.
McKenzie, yes.
McKenzie, aye. Medina.
Medina, aye.
Aye. Molina.
Molina, aye.
Molina, aye. Olage.
Belagi, aye.
Olage, aye. Pacheco.
Pacheco, aye.
Pacheco, aye. And you?
You, aye.
You, aye. Motion passes.
Thank you, Dr. Ladrine. Let us take a 15-minute bio break, 10:15 to return. Thank you, guys.
Well, you got the first and second.
You need to come here.
Thank you. We are now on item number 26D, I believe. Let's see where we are here, 26D. And that is a discussion and possible action on a legislative proposal to amend section BPC, section 1628.7, regarding a probationary license. And Ms. Regali, you're still up. Go.
Thank you. I will now be presenting agenda item 26D, which begins on page 178 of your meeting materials. This legislative proposal is regarding a issuance of a probationary license. Pursuant to Business and Professions Code, section 1628.7, the dental board may issue a probationary license to an applicant for licensure as a dentist or dental auxiliary upon an applicant's successful completion of the board examination. The probation is required to be for 3 years and allows the board to include terms and conditions of probation. Issuance of a probationary license is intended to authorize the board to settle the matter more efficiently for an applicant who would not otherwise qualify for an unrestricted license but may be safe to practice under specified terms and conditions. Currently, this section requires that the issuance of the probationary license be conducted in accordance with the Administrative Procedures Act, which would require referring this case to the Office of the Attorney General for filing of a statement of issues before the board can settle the license application matter. Since the original intent of the probationary license statute was to make issuance of a probationary license more efficient and avoid the delay and expense of filing a formal statement of issues, board staff are proposing amendments to resolve the issue. I also did want to point out that there are other statutes which allow different healing arts boards to issue probationary licenses without following the Administrative Procedures Act. And so we did review those statutes and we did make the different changes that we're proposing in this legislative proposal based on how that statute is written. The proposed amendments would better align with the medical board statutory authority to issue probationary licenses and would then serve the actual intent of the statute. We would clarify requirements for licensure and add a sentence identifying the board's ability to deny licensure based on unprofessional conduct. We would add language to advise the decision shall be posted on the board's website. We would remove subdivision C, removing the requirement to follow APA processes to issue a probationary license and therefore not have to forward anything to the Attorney General's office or file a statement of issues before issuing a probationary license. Add language to advise that a new application cannot be submitted until at least 1 year has passed from the denial of the initial application. Add language to clarify that an unrestricted license would be issued to the licensee once the probationary term is completed or upon termination of the probationary term. And we would remove subdivision D, which requires the board to adopt written guidance regarding probationary assignments as it's not relevant to the issuance of probationary licenses. The board's disciplinary guidelines with model language and uniform standards related to substance abusing licensees was standard language for probationary orders incorporated by reference in the California Code of Regulations, Title 16, Sections 1018 and 1018.01, respectively provide appropriate guidance regarding probationary terms and conditions. And we would also add language to ensure the statute's intent is clear and the issuance of a probationary license under this statute would not require adjudication under the APA. Additionally, we propose making other clarifying, non-substantive amendments, including renumbering the subdivisions and removing outdated language. So this proposal is essentially for license applications who we've denied, who we deem that they would otherwise not be issued an unrestricted license, and we would like to resolve them through a process that the board calls an in-house stipulation to probationary license. Therefore, we stipulate the terms and conditions, we go over the order, and it is still sent to the board for review and voting on. So it still would be considered. However, we would avoid the costly and inefficient process of sending it to the AG's office, filing a statement of issues just to do a stipulated settlement if we deem appropriate. Otherwise, having to go forward to an administrative hearing, which is also very costly on the applicants. So we're trying to streamline the process, and we're trying to follow the original intent, which is to be able to offer an in-house stipulated probationary license and avoid all of the other time constraining and inefficient ways of issuing it. The action requested is that the board is asked to discuss and consider the above described legislative proposal. If the board approves of the legislative proposal, the board is asked to include in the board's next sunset review report a recommendation to amend Business and Professions Code Section 1628.7 to clarify probationary license process and requirements. Thank you.
Thank you. Is there any board concern, questions? Dr. Molina?
On the portion that it says that it cannot be, a new application cannot be submitted until at least a year has passed from the denial of the application, that seems to be a long time.
So we technically currently follow this. We just wanted to include it within this statute. So the reason that we do that is because it essentially would be burdensome on the board and on the applicant to keep essentially applying for licensure without any provisions and regarding when they're able to apply after denial of a license. You can essentially change those facts within a day or within a week or within a month. So for them to reapply in such short time period, it's placing more workload on staff, and it's unnecessary denials for the licensee or the applicant. The intent is that we would allow certain people, licensees or applicants as appropriate, who wouldn't be issued unrestricted licenses, to be given an opportunity to prove that they can safely practice in California through a 3-year probationary term. And with the probationary term, they're still able to request termination of the probation after 1 year based on the 3-year requirement, and they still can follow all of the other consideration or provisions within 1686, which goes over all of that information. So we just think that it would be not effective for an applicant who was denied to be able to reapply a week later when the circumstances wouldn't change, rehabilitation criteria wouldn't change, et cetera.
Dr. Montez?
And so to clarify, this is just for a new application that was previously denied. There could be that was not denied, and then they would be under consideration for this. So we're not saying everybody has to get denied, wait a year, and reapply. It's just those that were initially denied, but we could have a new applicant who's never been denied and go through this process. Does that make sense?
Correct. So if they apply for license and we deem it appropriate that they could potentially practice safely, and we want to give that opportunity, they've shown some type of rehabilitation criteria, et cetera, we would give them this opportunity and offer. They can decline the offer. We would deny the license, and then they would have the process of appealing the license, and they would be able to go before an administrative law judge if they wanted to. So it can work both ways. But if they do apply and we're considering their application, we don't deny them right away. So with applicants, they apply, we tell them what they're deficient in, we work with them to comply with the deficiencies. Once they are complete and their application package is complete, at that point we would be reviewing it and determining from enforcement standpoints and through our executive officer whether this should be a denied application and given the opportunity for appeal, or if we would offer an in-house stipulated settlement to a probationary license, where we would then give 3 years terms as required by statute and then any other standard terms and conditions.
Any other board questions? Dr. Yu? Do you want to make a motion, sir? Go ahead.
Yes, okay. Decide to include the proposal in the board's next sunset review report a recommendation to amend business and the profession code section 1628.7 to clarify the probational license process and requirements.
Thank you. Is there a second? Dr. Forge? Thank you. Is there any further board discussion? Seeing none, are there any public comments? Seeing none, we are ready to vote. Dr. Lirin?
Chan?
Chan, aye.
Chan, aye. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, aye. Forge?
Forge, aye.
Forge, aye. Larin, aye. McKenzie?
McKenzie, yes.
McKenzie, aye. Medina?
Medina, aye.
Medina, aye. Molina?
Molina, aye.
Molina, aye. Olage?
Olagi, aye.
Olage, aye. Pacheco?
Pacheco, aye.
Pacheco, aye. You?
You aye.
You, aye. Motion passes.
Thank you. Thank you, Ms. Regali. We're going to move on to, did you want to make a comment on this? Go
I
ahead.
did. I just, again, want to thank the board for moving this forward because it comes up. I have seen some individuals who have really done an excellent job in trying to rehabilitate themselves. And unfortunately, they've gotten caught up in some delays with having to go through the process. So this is really a nice option to reduce barrier back into the profession or into the profession.
Thank you. And Ms. Welsh?
For purposes of the record, I think that Dr. Yu's microphone was off as he was reading the motion, so I just want to confirm for the record that Dr. Yu moved the motion recommended on page 181 of the meeting materials, just so we're clear.
I actually heard it, Ms. Welsh. That's good. All right, let's continue on. Thank you. We're now going to go to item 26E, a discussion and possible action regarding penalties for fraudulent advertising and misinformation of dental assistant educational programs and courses. Dr. Montez is going to speak to this. We spoke about this at the DAC yesterday as well.
Correct. Good morning again, Tracy Montez. This was an item at the Dental Assisting Council, and I had shared that through communications with professional associations and stakeholder groups, the dental board staff have become aware of fraudulent advertising and misinformation distributed by dental assistant educational programs and courses. Examples that were included were false statements on their websites about the board accrediting their programs or courses, which we don't do, we approve or not approve. Also, trying to solicit students when the program is not yet approved, making promises about courses that may or may not be accurate. And as our dental assisting council, they shared their own experiences with this fraudulent misinformation that's come to their attention. And so really in being responsive to protect our students and our applicants and the board's reputation as well, we would like the board to include this issue in their sunset report and specifically request that the California State Legislature create a clear enforcement action statute with prescribed board administrative enforcement actions to combat fraudulent advertising and misinformation distributed by educational programs and course providers, specifically that there would be a violation of Business and Professions Code 17500, and the board would have the authority to issue a citation with administrative penalty. And again, I'm happy to answer any questions, and I know our council would like to elaborate on this as well.
Ms. Welsh, go ahead.
So I guess the legislature is now requesting that boards in their sunset reviews provide some sort of resolution with their issue that they're presenting. And so what we discussed at the DAC yesterday was fleshing out a little bit more what the enforcement action would look like. So we were, just providing to the legislature the concept for resolving this issue. So if you don't mind, I can read what the DAC approved yesterday as the recommendation. The recommendation is to include this issue in the board's sunset review report and request that the California State Legislature create a clear enforcement action statute with prescribed board administrative enforcement actions such as issuing to an educational program or course in violation of false or misleading advertising, a citation with an administrative penalty to be determined by the legislature to combat fraudulent advertising and misinformation distributed by an educational program or course provider.
Thank you. Is there any board discussion on this? We don't have a motion as yet to do this, so would like to see a motion.
Okay, you
Dr. Yu, please, make sure your microphone's on.
Yes.
Thank you, sir.
Motion to include the issue in the board's next sunset review report.
We better be a little more specific than that, I think.
Would you like me to read the full motion with the DAC's recommendation?
We can use that as our motion, and someone will take responsibility for that. That would be wonderful. I think we need more information than just to include it. We have to explain what we're doing.
Dr. Yu's motion is to recommend including, well, the motion is to include in the issue in the board sunset review report and request that the California State Legislature create a clear enforcement action statute with prescribed administrative enforcement actions such as issuing to an educational program or course in violation of false or misleading advertising, a citation with an administrative penalty to be determined by the legislature to combat fraudulent advertising and misinformation distributed by educational programs and course providers.
Thank you. That's what you were saying. Is that correct, Dr. Yu? I knew that. Is there a second?
Second.
Second, I heard it, I didn't see it. Who's seconding? Mr. Medina. All right, we can't make everybody a doctor today. Ms. Medina, good morning. All right, and so that's a second. Is there any further board discussion on this?
I just have a question.
Dr. Liren?
So no certificates are handed out to educational programs that are approved by the board? There's no, why is there not any program?
No, where they're given an approval status, they're just not accredited. And so those terms have some different meanings in terms of how schools advertise.
Okay, but how do they prove that they are approved? How do they prove that
There's a process where our subject matter experts go through provisional site visits, and then on-site visits. They have to turn in materials, go through that, then they become approved, and then it's posted on our website.
Oh, so
But we have schools that are claiming to be approved or claiming to be accredited or have applied, so sign up, even though it may take some time, or they may never be approved, so.
Yeah, I understand that. What I'm asking is, do they not receive a certificate of approval, or do they receive anything to prove that?
Yes,
They-
yes,
oh,
they
okay.
do receive paperwork, yes.
Here it says they don't, but thank you.
Okay, I think we have it moved and seconded. Is there any further board discussion on the motion? Dr. Chan, are you? No, you're not. Okay, any public comment on this? Ms. Becker?
Here's a, see, no license issued.
Sherry Becker, representing the Alliance. We are in support of this motion. Thank you.
Thank you. Any other public comment? Okay, Dr. Loreen, I think we're ready to vote on this. If you would like to, do you want to read the whole resolution back to us? You don't. Okay, but it was the one that Dr. Yu put into the record for us. Thank you, and go ahead.
Chan?
Chan, aye.
Chan, I. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I. Forge?
Forge, aye.
Forge, I. Larin, I. McKenzie?
McKenzie, yes.
McKenzie, I. Medina?
Medina, aye.
Medina, I. Molina?
Molina, aye.
Molina, I. Olage?
Olagi, aye.
Olage, I. Pacheco?
Pacheco, aye.
Pacheco, I. You?
UI.
Motion passes.
Thank you, Dr. Loreen. I think we're going to move on now to, I think it's item number 27A. Mr. Bergman, if you will, the tentative legislative calendar. Dr. Loreen? Dr. Loreen. Go ahead, Mr. Bergman.
Thank you, President Felsenfeld and board members. The tentative legislative calendar, and that's the legislators' words, not mine, can be found on pages 187, starting on pages 187 of the meeting materials. We are effectively in the last month of this year's legislative session. The legislature has until September 14th to pass any bills that have a chance to become law this year. Now, the governor will have 30 days from the time in which he is presented with a passed bill to sign that into law. So, and that's date specific. If he were to be presented with legislation today, he would have 30 days from today. And since the last day of the session is September 14th, most of what he's going to get on September 14th, he will have until October 14th to sign into law. And unless the legislation stipulates a different effective date, these bills would come into effect on January 1st of 2024. The other relevant deadlines to consider in this last month is that at this point, bills are with their respective appropriations committees. Those committees have until September 1st, with basically 2 weeks from today, and to report those bills to the floor. And then the respective houses would need to pass the legislation, concur with any amendments that the other house has made, and then present them to the Secretary of State, present them to the governor for approval and chaptering by the Secretary of State. That concludes my report with respect to the calendar, and so if there's any board discussion, we can entertain that at this time.
Is there any board discussion on the calendar? Seeing none, is there any public comment on the calendar? Once again, none, so we will move on to your next item, which is going to be a little bit more meaty, I think, and that's prospective, sorry, I made one.
Certainly.
Legislation of interest, is that correct, sir?
Exactly,
All
sir.
right,
This is-
27B.
Yeah, 27B, the memo for this item begins on page 191. I want to, I'll cover all of the various bills that are entered on the agenda in brief, and we can focus on those bills that the board took a position on at its May meeting. Since the May meeting, the main activity in terms of the bills that the legislature, that we have been tracking, is the AB 952, which is a bill concerning dental coverage disclosures by insurance plans and healthcare services plans. It's something of interest to licensees, but not of any particular impact to the board. That was signed into law on July 27th. So that will take effect at the beginning of next year, but again, not something that the board needs to be concerned about. Our licensees may find that of interest. But the other legislation that we've been tracking, none of that has yet been signed into law, aside from the declaration making last February Children's Dental Health Month. In our May meeting, the board took positions on the following legislation: AB 481. This was a supportive amended position, but based on subsequent amendments to this bill, as you're well, President Felsenfeld, in consultation with Member Pacheco, you amended the board's position to strictly support at that time. We can get into this in just a moment. The DAC has made some recommendations based on subsequent amendments to the legislation. I want to address that after I cover the other bills that the board took a position on. AB 936, which would expand the pool of dental students that could participate in healthcare-sponsored events. Board took a support position. That legislation is still moving through the process. It is an urgency bill, so if that does become law, it would take effect immediately upon the governor's signature. AB 1552, a bill concerning reverting the approval process for foreign dental schools back to the board. The board took an opposed position on that. This legislation is not expected to move forward this year, and that situation remains the same. SB 372 is legislation that the board took a watch position on concerning how the Department of Consumer Affairs boards address scenarios where an individual who has a name or gender change, how the inquiries about past disciplinary histories are considered. That bill is continuing to move forward, and the legislative process has not been passed yet. And then finally, SB 544, this is addressed earlier in public comments. This would allow the boards to resume teleconferencing, teleconference capabilities for meetings, slightly amended from the procedures that were permitted during the pandemic. That legislation was amended this week, and the specific amendments to the bill is that it imposed a sunset provision, which means that if it would be passed, those new provisions would only be in effect until January 1st of 2026. Additionally, there was a stipulation placed on that board members or any members of state agencies that are subject to this legislation would need to be physically present at least half of the meetings that are conducted during that year. So, and specifically, at least half of the members would need to be present at least half of the meetings. With guidance that we would eventually receive on this would probably help clarify the obvious questions you may have about exactly how that would be counted. It's unclear at the moment based on the language. But that's the situation with respect to the bills in which the board took a position on. As I indicated before, the DAC has made recommendations with respect to amendments to AB 481 that was covered in Chair Reed Espinoza's report. So it would be up to the board to consider whether they want to go ahead and officially pass those along, or if there are any other things that they would like to add, and of course, if there are other things that they would the board wishes to consider with respect to any other legislation that we've got on the agenda. So that at this point, that concludes my report. I'd like to open it up to board discussion.
Are there any questions on anything that Mr. Bruggeman has told us today? Are we comfortable? Looks like we are. This is going to be informational at that point, so I would say, is there any public comment on anything that we've been talking about?
I would just want to clarify that we would not need to make a motion based on the recommendations that the DAC provided.
I think the board needs to consider the recommendation and consider also whether the board needs to change its support position, depending upon the necessity for those proposed amendments. I mean, if they're really important to the DAC, they likely really need to be in the bill. So the board would really want to pursue that and issue a letter probably to the author's office requesting amendments. And Tracy has something.
Or as an option, could the board delegate to the executive officer to continue working with CDA on this bill regarding the recommendations or requests from the DAC?
It could. I'm just cautioning that approach just to make sure that the board already has a support position on the bill. So if those amendments are not taken, that may be a problem. Because if you're authorized to just work on amendments and they don't take them, and there's nothing to suggest that CDA is not willing to engage in conversations and make these amendments. But
Agreed.
if they didn't make the amendments for whatever reason, just to slam the bill through. We know that it's getting close to the end of session and policy committees have already passed bills out. So if they decided not to include the amendments, that would be problematic, and the executive officer could not change the board's position on the bill. So perhaps it would be better to delegate to the board's executive committee the ability to change the board's position from support to watch or oppose if the amendments are not taken.
Okay. Is there any discussion about the concept of that? Let's start off with that. Any board member discussion on allowing, and I think what your suggestion, Ms. Welsh, if I'm hearing everything correctly, is that probably the better way to do it is to have the executive committee make some final decisions on behalf of the board? That was just, okay. So, and actually, we've already done that one time with respect to this. This bill is a very large bill, lots of moving parts, and they're all going in the right direction. It's been a very good cooperative effort between CDA and the board, and we'd like to see that going on. And we want to see what we can do to facilitate the comments of the DAC into that as recommendations. So, so I would suggest, if there's no other, any board comment on that at all? Do we get a sense that it's an okay thing to do? If that's the case, I think we should make a motion that the executive committee of the board be charged with, let's put the words correctly, charged with assessing the recommendations to AB 481 from the DAC and working with CDA, or we're working with the author, let's put it that, working with the author to facilitate their inclusion in the bill. And that if they are not included, the committee would have the capability of changing our position if they felt it was necessary. Let me ask our two, are we good with that, Ms. Welch? Wait, she's got something else.
How would you propose the executive committee potentially change the board's position to a watch or an oppose?
I think that would have to be a decision if we feel that something that the DAC has asked to be included is so important and they don't, then we might say opposed if not amended. I'm not sure. I remember all the things going on. There's a lot of them there, and some of them are probably not as important as others, but I think that would have to be left to the discretion of the executive committee.
Okay, how about this as the motion? Motion to authorize the board's executive committee to assess the DAC's recommendations on AB 481, work with the author to facilitate inclusion of those amendments in the bill, and if the amendments are not included, authorize the executive committee to change the board's position as needed.
That's pretty much what I said. That would work. And I wouldn't say if they're not included, well, leave it that way. It's not that all of the amendments are going to be included necessarily, but if there's some concern about what it says and it's not consistent with what the DAC was asking, and we felt that those were good, then it would give us the ability to make a change in our position, which isn't going to change what happens to the bill, but our support is probably important in this kind of a bill. So what you said is what I said, pretty much. All right, did anyone want to second that?
Pacheco, second.
Pacheco, the vice president, the other half of the executive committee. All right. We have that before us. We can read it one more time as we get to the actual vote. Is there any other board comment on the taking the position on AB 481 relative to what our DAC has asked us to do? Seeing none, we have the motion, and the motion's been seconded. So is there any public comment on that? Oh, well, hang on, here it comes. All right. Ms. Rita Espinosa, go ahead.
So we just wanted to change.
Read your name in for the record, please.
Sure.
Sorry.
Tracy Reed Espinosa, Chair for the DAC.
Thank you.
You're welcome. There's just some word tweaking here in regards to this. And so the motion seems to be very large in the fact that if this doesn't go through, you guys can just completely disband 481, and we don't want that at all. So I just want to state that there's a few words that need to be changed or a comma that needs to be placed in, and we would like to move forward with that, for the record.
We don't usually respond to public comment, but I think it's giving us the discretion to make those decisions is what that motion is really doing. So I don't think you have to worry about that is what I'm saying.
And 481 will continue moving forward because it's not the board's bill. So
Okay.
it will either be amended or not, but it will likely continue moving on. The board may have a position, but again, we're not the author, so it will be just a piece of information associated with the bill.
Okay, thank you.
We don't control where it goes, is what it comes down to. We only hope. All right, Ms. Sakai.
All right, good morning. I'm Tuka Zokai, representing the California Dental Association, or the author of AB 481. We have appreciated working with Tracy Montez and learning more about the board's needs and working together collaboratively to have a support position in moving forward 481 and really more pathways to dental assistant licensure. We understand that there have been some suggestions by the Dental Assistant Committee, and we've already been working on incorporating those since yesterday. So this is something that we want to continue to move forward collaboratively with. And while Tracy did say that the motion does seem large. We do understand that there is a process to looking at these recommendations, and just wanted to reassure the board that the California Dental Association is looking at those non-substantive changes to make sure that this bill does move forward comprehensively while also making these pathways easier. And we appreciate your support position.
Thank you. Is there any other public comment on this motion?
Dr. Bruce Witcher, CDA. I think the concept is what we're looking for is technical, non-substantive type changes, if I understand, Tracy's comments. So, of course, we'll consider anything, but obviously we would be disappointed if the board were to change its position to oppose unless amended. That would, make it difficult. So, thank you for that.
Got that. Thank you, Dr. Witcher. Any other public comment?
Sherry Becker, representing the Alliance. We appreciate the board's consideration of the DAC's recommendation. Thank you.
Thank you. Any other public comment? Seeing none, Dr. Loreen, I'm going to ask if Ms. Welsh would be kind enough to read out the motion in its entirety as we've perfected it, and then that is what we will be voting on.
The motion is to authorize the board's executive committee to assess the DAC recommendation on amendments to AB 481, work with the author to facilitate inclusion of the amendments in the bill, and if the amendments are not included, authorize the executive committee to change the board's position as needed.
Thank you. Dr. Loreen, take the vote, please.
Yes, I just want to clarify, Felsenfeld was motion, right? You made
My
the
motion, and I can't remember.
Pacheco?
Pacheco seconded
Okay.
it. That's correct.
Good. Chan?
Chan, aye.
Chan, aye. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, aye. Forge?
Forge, aye.
Forge, aye. Ladin, aye. McKenzie?
McKenzie, yes.
McKenzie, aye. Medina?
Medina, aye.
Medina, aye. Molina?
Molina, aye.
Molina, aye. Olage?
Olagi, aye.
Olage, aye. Pacheco?
Pacheco, aye.
Pacheco, aye. And you?
You, aye.
You, aye. Motion passes.
Thank you. Item number 28, Mr. Bergerman, I think it's still you, and we'll talk
Yes.
about prospective proposals.
So the public and other stakeholders always have the option to present a legislative proposal to the board if it is simply with the caveat that it's something that is presented to the board today, we would not be able to act on that today. It would need to be agendized for a subsequent meeting, so that this is the time during the meeting which any members of the public would be able to come forward with any prospective legislative proposals that they'd like us to consider, or
Okay.
like the board to consider, excuse me.
Thank you. And the board want to make any comments on that? Because this is mostly for the public to comment? No? Is there public comment on any potential legislative proposals that we could think about for the future? Seeing none, thank you, Mr. Bergerman, we're good. I believe this is going to conclude our meeting, so I want to thank the board staff who always work very diligently and keep us honest, the board members for all your work, and the public for all the good comments. We appreciate that. This will then conclude the August 17th, 18th, 2023 quarterly dental board meeting. The meeting is adjourned.